the record building is very important, even when you're just dealing with the RFE stage or noise stage. I think it's always important to get your arguments in so that you put the agency on notice. I always, for example, when I'm dealing with a tough RFE or tough noise, I always side check the case law they cite to. Some of them are just ridiculous. Some of them have no relevance.
Because these are being written, the decisions are being written by non-lawyers at USCIS, typically.
Right, they just copy from the template. So I always side check, I always argue back, because I think this is important, because once we go to district court, we're not allowed to add anything else. The entire record is everything. So
right. The certified administrative record produced by the government, that's the Administrative Procedure Act. You don't get discovery typically. You're limited to 4 corners of that 1,000 pages or whatever. So you're saying you really got to get all that evidence in at the agency level when possible.
Right. And especially if you want to use due process violation as an argument, you want to get your arguments in so that the record is clear that the government is even on notice in the RFE response that they did these things wrong. They should have given us an opportunity to cross-examine these evidence or witness, and they chose not to. I think that will even help better at the district court level than developing this entire argument without anything in the record to show that you put the agency on notice.
Absolutely. And one of my, not criticisms, but as a former immigration lawyer where I did a lot of RFE responses, there's a natural tendency, I think, for immigration lawyers at the bar to argue things through the cover letter, argue things through the arguments of counsel, and USCIS routinely says that's not evidence. So for me, if I have to do something, I'm going to have the client put it in an affidavit, put it in an unsworn declaration. I'm going to have them state it. I'm going to attach documents to their declaration affidavit. And that way those documents get into the actual USCIS file, which then become part of the certified administrative record. You can't just say in your cover letter, I'm citing to something. I've had people say they've dropped a footnote or dropped a link in their RFE cover letter, and that information never gets into the record. Of course, you need to actually print out that website or print out that article, and then you need to have your client or an expert witness, someone else other than the lawyer, refer to that in their expert opinion letter, and then all of that information goes into the record. So how you make your arguments are going to be crucial when you, again, as you said, when you get to the district court level and you're looking at limited record.